Yeah.
Court does call the case. People versus Bernard Brock.
Assistant Public Defender Davy Lebo for Mr. Hart, who stands to my right, and we do have an agreement whereby he'll be waiving his exam.
On all of these cases?
Yes, Your Honor, if I could place the agreement on the record, please.
Go ahead.
Thank you. In the 25F55814 matter, the agreement will be that there be an offer at circuit court for a plea to count 1 with a dismissal of counts 2 and 3. In the 5854 matter, there is an agreement to a dismissal of count 1 upon a plea to count 2. And in the 1168 matter, there is an agreement to dismiss that case in its entirety upon pleas to the other 2 matters.
That's all.
And I have the waiver.
Mr. Hart, you understand that you're waiving your right to preliminary examination in these 3 cases?
Yes, Your Honor, I do.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir, I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further proceedings?
Yes, sir, I do. I do. Yes.
For the
One other
record,
thing, I want to thank you for giving me the opportunity to do that. Because
I'm sorry?
I want to thank you for giving me the opportunity to do that because you've listened to me instead of just rushing me along. The whole time I've come in front of you, every time you've listened to me, and I appreciate that. Thank you. And I'm going to Don Farms now because of you. Transitional. You wanted to send me to Hope, Mercy, whatever, but Don Farms is local, and I've been there before 5 years ago, and they're great.
This is a surprisingly wholesome courtroom moment. Instead of arguing about charges, the defendant takes time to thank the judge for listening and helping him find a treatment program. Those moments are rare, and judges remember them.
They're great. I appreciate you.
Well, thank you, sir, for saying that. Then that I'm not sure what to say, but that means a great deal.
How about go blue? Huh?
No, that doesn't. That
Go
really
green?
can't. That's really hard for me to come out of.
I
my
know.
mouth.
Thank you, though.
But I can say go Terps.
For real.
But all right.
Have a good rest of the day. Thanks.
Well, hold on.
Not done
Got
yet.
it. We still got more to do here. So,
Okay.
preliminary examination having been waived, defendant is bound over in the case ending in 1168 on the single count. In that case, in the case ending in 4545, he's bound over on counts 1 and 2. And on the other matter, he's bound over on count 1 with counts 2 and 3 following.
Your Honor, we acknowledge receipt of the information, waive formal reading, and stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pretrial in these matters will be set
January 20th, 1:30 before Judge Conte.
January 20th, 2026, 1:30 before Judge Conte.
Yes.
Bond in all of these matters will.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir, and
I
good luck to
appreciate
you. That's called the case of the people versus Germaine Johnson.
Assistant Public Defender Kelsey Regiles with and on behalf of Germaine Johnson, please take name.
Germaine Johnson.
Thank you. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he is going to be pleading guilty to the charge of attempted resisting and obstructing the 1-year offense. On his successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement. The sentencing judge waiver is not checked, but that was reviewed with him.
Oh, I'm sorry. You understand you wouldn't be sentenced in front of Judge Simpson?
Yes, yes.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. State your name, please. Germaine Johnson.
All right. Sir, it is this court's understanding that you are going to be, well, hold on a second. Yeah, there's two cases, and I'm sorry, I didn't go through the other one. In the other matter, that being the case ending in 5805, he's going to be pleading to use of cocaine. That's a count 3, and counts 1 and 2 would be dismissed. And the sentencing judge waiver would also apply to that one. You understand that, sir?
Yes, yes, I do.
Yes, Mr. Carr. You've been sworn. Sir, I do, on the one case, court believes you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
I understand, yes.
And on the other matter that you're going to plead to the charge of use of cocaine, that's also a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that? Sir?
Yes, I do.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentencing these matters before Judge Valvo, Valvo or her successor, which we kind of know now, but
I understand.
I'm not sure the dockets will stay that way, but you understand that, sir?
Yes, sir.
All right. Understanding that, do you still wish to plead guilty to these charges?
Yes, I do.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
I understand. Yes.
You signed or had cause to be signed an advice of rights form
Yes.
on your behalf. Is that correct? You have any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I understand. Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I'm into
of your own free will
sir.
and because you believe that you're guilty of this?
Yes.
Yeah. Okay. On the date, starting with the attempted resisting and obstructing on the date of November 24th, 2025 at the location of Las Vegas Drive near Palomar Drive in the city of Ypsilanti or city of Ann Arbor, Washington County, state of Michigan. Did you come into contact with police officers from the Ann Arbor Police Department?
Yes, sir.
What happened?
I rode off on my bike.
You what?
Rode off, tried to get away.
Did they give you an order to stop?
Oh, they told me to stop.
They told you to stop. You said, I'm not stopping and just kept going.
I was thinking about Thanksgiving.
You were thinking about what?
I was trying to make it to Thanksgiving. I promise. Yes.
What day was Thanksgiving?
Was it 20? When was it 24?
Mhm.
Trying to make it to.
So 3 days before you were trying to make it to Thanksgiving, where were you going?
I was trying to make it home.
Okay. Oh, no.
I myself in
Oh, gotcha.
a bit.
I see what you're saying. That didn't work out, did it?
No, I did not.
Yeah, it didn't. Okay. And you knew that they had given you a lawful command at that
Yes.
point, and you disobeyed it.
Yes.
All right. The other case. Well, these would be uniform, there wouldn't be a problem. Well, I'm not gonna worry about it, we'll just find it in here. Seriously, people. On the date of June 4th, 2025, at the Packard Road near Platte Road, city of Ann Arbor, Washington County, state of Michigan, did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
All right. Sir, I do have to advise you that if I accept your plea, between the time that I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not, first of all, not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty in each of these cases to count 3, counts 1 and 2. I think the both matters are dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
Third at 9 a.m. For Belleville.
February 3rd, 2026, 9 a.m. And it's before Judge Valvo in each of these cases. On will continue. He has I did, so that you're aware, I don't know if it was sent to you, their they requested that he be released to treatment. I approved that on his cases. So he might go to treatment. That was something through the sheriff's department that they sent us.
The defense is asking for trust, but the judge remembers something important. This defendant previously had warrant issues. In court, credibility is earned over time, not promised in a single hearing.
Would Your Honor consider, in light of the plea, a personal bond today and then allowing him to, of his own volition, seek treatment?
You really want to go back through the warrants where we had to find him?
Oh, you're not gonna have to find me.
Well,
We do
Yeah,
have his
I mean-
current address. We know where he would be located.
I should have just let it go. What I was trying to tell you is I've signed an order to release to treatment.
Oh, yeah, that's fine too.
And that was sent through the jail process as opposed to, and I've approved his release to treatment. If you'd like him released on a PR bond, you can take that up with Judge Pablo's successor or whoever's handling it. I'm not going to change it at this point.
I understand.
All right?
Thank you, Your Honor.
Thank you, sir. Good luck to you.
You have to fill out his packet.
Okay.
Court does call the case of the people versus John Brown.
Brian Bowling on behalf of Mr. Brown. State your name for the record, please.
John Brown, how you doing, Your Honor?
I'm doing okay. I may be.
Judge,
Go ahead.
for purposes of the probable cause conference, I'm asking for an adjournment so that we can review the video from the incident with Mr. Brown.
You have his violation.
I do. I'm aware of it. Mr. Brown and I have spoken about it, Your Honor. Thanks.
Okay.
Your Honor.
Want to deal with that? I'll give you the adjournment.
Yeah. Ultimately, Your Honor, Mr. Brown, I would advise you against saying anything.
Well, I just wanted to speak on the violation. So
I was going to speak on the violation, but you're welcome to do it if you'd like to.
honestly, Your Honor, it was on a violation. It was a misunderstanding. When I went over there to drop, and then she called me back for a phone interview. I asked her what was next, and she said that would be up to the judge. So 3 days later, I spoke to Alexis, my old lawyer, while I was at work, and
Your Honor, may I say something on Mr. Brown's behalf with respect to the violation? Judge, he would admit to missing those tests on November 13th and December 18th. However, he did report and tested on November 3rd. He's currently on,
And it was positive for THC. You got a medical marijuana card?
he does not, Judge. He indicates to me that he's on probation with Judge Slay. To my understanding, that's going very well. He did surrender himself on this matter to address this case. He does want to comply with this court's bond conditions. He wants to test as ordered.
Then why didn't he go?
Well, he did go originally, Your Honor,
Yes, went and he's positive for a drug he cannot by court order. So
Granted.
then we don't see him again.
well, like I said, he is on probation. There is an order with that court and that status to test. I do believe Mr. Brown, and we spoke last night after receiving this report, where there was a misunderstanding with his discussion with Ms. Dozier that the testing that he was doing on probation would be satisfactory for the purposes of bond. That turns out that was his understanding. That's not accurate, Judge,
Is that where the case? Why did he go on the 3rd?
because that was the initial intake. That was the initial test. So if the court would allow him to go over to community corrections now, he could get testing established and he would continue testing. I cleared it up with Mr. Brown when I talked to him last night and today.
He still doesn't have a card. Is marijuana going to show up in your system?
It will, Judge.
a little bit will. Your
A little bit?
Yeah, I don't know how the levels
Just
go
a little bit of weed.
because I don't know how the levels go on New Year's Eve. I don't drink, so I did eat an edible.
Smoking what you got.
I mean, I'm not gonna lie to you. I mean,
No, I don't want you to lie to me. I'm just saying you're on bond.
yeah. And I didn't even I was up until I spoke to him yesterday. I was unaware that it was even illegal to smoke marijuana because it's legal. So it really was a misunderstanding.
The defendant admits he misunderstood the bond conditions, but the judge's response is simple. When you're out on bond, it's your responsibility to know the rules. Fortunately for him, He's getting one more chance to prove he can comply.
Your Honor, I'm asking you not to lock me up for it. Right now, I'm working. I got a full-time job. I really can't afford to lose no days right now.
Should have gone testing. What I'll do is I'll only set it out 1 week to the 15th. But you guys try to figure that out and maybe give me the testing that he's doing on his other matter in circuit court. But at this time, the defendant's bond to revoke.
Thank you, Judge.
Assistant Public Defender Hannah Apple appearing on behalf of